The House Appropriations Subcommittee on License and Regulatory Affairs and Insurance and Financial Service will come to order. Chair, will you please take roll for today?
Chair Beeson?
Here.
Representative Steele? Here. Van Workum?
Here.
McKinney?
Here.
Snyder? Mr. Chair, you have 4 members present, 1 absent, you have a quorum.
Thank you. Rep. Steele moves to approve the minutes of March 13th, 2025 subcommittee meeting. Hearing with no objections, the minutes are adopted. Next, we have a presentation from the Michigan Indigent Defense Commission. Kristen Staley, Executive Director of Michigan MIDC. Please come on up. And thank you for being here for this presentation.
Absolutely, thank you. Give me 1 second here. Okay. Thank you so much, Chair and Vice Chair and committee members. It's really great to see you all again and some new faces, so thank you for having me here today. Just going to talk briefly about what it is that our agency does, why we do it, how we do it, and the impact that we've been making since we've been in existence. Just to start briefly about why we exist, I always like to begin with, that we are here to provide the state's obligation of meeting U.S. constitutional and Michigan constitutional rights that any person, to quote Gideon V. Wainwright, who is hauled into court, who is too poor to hire a lawyer, must be still assured a fair trial, and the state must be providing that counsel for them if they cannot afford counsel on their own. This Gideon, of course, is a landmark old case from the 1960s, but it did take quite a bit of time before Michigan was able to meet its obligation that we've seen other states meet before us. When the MIDC Act was enacted in 2013, and a long period of time of decades between Gideon being ruled upon, we saw lots of work being done through the Snyder administration, through prior administrations. There were task force and independent reports, and this bipartisan effort that created the MIDC Act it oversees everything that we do at the Indigent Defense Commission. So the statute has very strict requirements in terms of what our agency must do. We develop and oversee the implementation of minimum standards on the delivery of indigent defense at the trial level defense services. We administer grants to all local systems so that we can help our local systems meet the minimum implementation of these new standards and come into compliance to just ensure that everybody is meeting the constitutional minimums. We monitor this money and this grant funding, as well as the compliance and the programmatic work across the state. We are also mandated to collect and analyze data that comes back to us from this grant funding and this grant program. And we're also mandated to encourage best practices across the state. So not that we're meeting the bare minimum, but of course that we're exceeding. The Act also created a commission to oversee all of this work. It's a 19-member commission, with 18 being appointed by the governor, and 1 is a seat for the Chief Justice of the Supreme Court. As you'll see here, it's a large swath of everybody who is connected in some capacity to the criminal legal system, from judges and defense and prosecution to townships and county associations, the general public. The commission is a public body, of course, and it meets 6 times a year in public, and is an Open Meetings Act, under the Open Meetings Act. The commission, of course, as part of the MIDC Act, has created 9 minimum standards for the delivery of public defense. These standards are, unfortunately, pretty foundational, but before these standards existed, These very foundational minimum guidelines here, or standards, really weren't being achieved across the entire state. These come directly from the ABA, National Best Practice Standards for Delivery of Public Defense, and it includes things from a minimum of annual criminal legal education for attorneys across the state to ensure that attorneys are actually meeting with their clients within a minimum time frame after they're assigned. It ensures that there's funding set aside and usage of investigative and expert services, that counsel is actually showing up for all critical stages, including first appearance or arraignment, that the public defense system is independent from the judiciary, and similar to how the prosecution is independent or retained counsel would be independent. That there are case caps on workloads and caseloads so that we don't have, which is being implemented right now, so that attorneys out there are not overworked, and burning out, and ensuring that everybody is able to focus directly on the case at hand right in front of them, which is part of your basic standard of ethics as being a licensed attorney. We ensure that the attorneys who are taking assigned cases are actually qualified to take these cases, that it's not a brand new graduate from law school who is given a homicide case on day one, that they are reviewed annually they were reviewed throughout the year and throughout their practices to make sure that they actually are still competent and are keeping up with best practices. That attorneys, we also have a standard that ensures that attorneys are given a livable wage and minimum standards. That there's not a disincentive to provide public defense services. And then we also ensure that there's not justice by geography, ensuring that there is a standardized statewide determination of indigency and contribution across the state, so that if you, it doesn't matter if you're in one courtroom or the other, and if your qualifications for these public defense services are standardized. To ensure that our standards are being adhered to and that the grant funds that we provide for our local systems to help them come into compliance is being overseen, we have a wonderful staff. It's a small but mighty team that we have of 18 people. We are currently funded for 18 FTEs. We do, however, have an authorization for up to 21 FTEs currently for this year. I cannot say enough wonderful things about the team that I work with. We have, I'm here today with my legislative and state administrator, Marcella Weststreet, and we have a deputy director and training director. Because we're a small team, we have some folks who wear multiple hats. And we have our field, what I'd like to talk about is our field staff. We separate the state up into 6 sections, and we have regional managers that oversee each one of those regions. There are our frontline field staff who provide technical assistance, customer service as needed. They monitor in real time. They are in the courthouses and the jailhouses, and they're all, have past lives of being public defenders themselves or working in the criminal defense world. So they know what best practices look like, what they should be doing. They help think through troubleshooting and innovation out in the field. We have a grants team that oversees every single penny that goes out the door into the local systems. We have a grants director and 2 analysts that looks over every single bit of data that comes back to us, oversees the annual auditing that we provide when we contract with a CPA firm to ensure that the grant funding is being used appropriately. We also have a training division of 2 people. One is a grant-funded right now project manager, and we have a training analyst, and they help oversee the attorney education and qualification standards, and making sure that we can provide from our office free trainings to the local systems at a low cost. Training is, I'll talk a little bit more about what we do for training. It really is their best bang for the buck. It can be done very inexpensively and really changing culture. And of course, we have our research team. We're very lucky to have a research director and an analyst to oversee not only just the collection of the data that we get in from the compliance work out in the field, but we're also able to now assess and see the impact of what we're doing and how we're greatly improving the systems that we're helping and serving. We also help our local systems because we've seen major growth where brand new public defense offices were built or brand new ways of doing work. And so we help them create their local case management systems or help them think through how can we do the best work. Our funding comes for public defense. It comes majority from the general fund through our MIDC grants out to the local systems. However, our statute does require that local systems maintain a local share. And just to kind of clarify, when I say local systems, it's statutorily defined as the local trial court funding unit. So it could be a county, could be a city, could be a township. This is a fairly static number. Currently, this year in FY25, local shares is about $38.8 million. The state grants that we provided in FY25 was from the general fund was $258.3. And we do allow a collection of attorney fees or reimbursement. Not all systems collect this, but of those that do, we estimate it's about $300,000 each year that comes through. These grants primarily promote and support the growth of public defense through building jobs, through creating, as I mentioned, creating new offices. Many of the counties chose, we are in our 7th grant year at this point, so we're still what I would say quite early in doing business. We've seen huge amounts of change locally. In the first couple of years, we're kind of slowing down in terms of who's building brand new offices and who's hiring and moving and changing their ways of delivering systems. But at this point, we've seen county offices being built. We've seen brand new positions like manager and counsel attorney, administrative offices, things that never existed at the trial level in the state before. We're seeing brand new positions at the trial level that never existed in terms of social workers being in the public defense field, that having full-time investigators on staff for public defenders, things that never existed before these grants were out there. Again, these are all parts of providing effective assistance of counsel, maintaining best practices. And as you see, over 90% of this funding goes to helping and supporting people. These are jobs that are, being built at the local level, and it's some of it does, of course, go to, like I said, the defender training is, very small but very mighty. It does promote the change of culture, ensuring that everybody is getting their, being educated and improving their services each year. We are seeing an uptick in expert investigative funding being used, and this is massive. While it does look like a small percentage, this never really existed before. So to even see this improvement is fantastic. And then, of course, there's a small percentage that also goes to maintaining these offices that we've helped create, whether it's the case management program systems or just something that needs to operate an office. We also have, over the years, accumulated 2 work projects that are currently active. This comes, again, these are brand new grant programs that we just started. The first year was in 2019. So there was a bit of, and these were brand new ways of doing business locally, so there was a little bit of educated guessing in the first handful of years, and that's really what this reflects. It's a lot of what we call unexpended local grant dollars, rolling over from year to year. However, the work projects do support the actions of the local systems because, again, it is difficult to estimate what the caseloads are going to look like next year, or what if there's going to be a big case or a reopened cold case. You really don't know what's going to be coming through the courthouse doors. So this funding goes to supporting reimbursements for if there's any overages due to big cases that are out there or unexpected casework. It supports our continual financial audits throughout the year. As I mentioned, we've contract with a CPA firm. We've been very, very happy to work with them, and we're working slowly through every single system across the state right now. And of course, the law changes constantly, right? It is active, and so we've seen quite a big changes from our Michigan Supreme Court that have come through mid-year of the grant year. And so these are just a few of the cases. These relate to the changing of juvenile life without parole age ranges and having to have retrials, which is, again, going back under our grants because it's at the trial level. And so that's why this funding is set aside. And I mentioned a little bit in terms of our org chart, but we provide not just in-field, real-time access, customer service access to our staff and to our team, because we are here to help those local systems improve their services, make sure that they're complying with the bare minimum, the minimum standards. But we also see many, many of our systems that are going over and above. This is here, while it's a lot of bullet points, but I put this here just to show a little bit of what our calendar year looks like. We're a compliance team, but we're also a granting agency. And so we want to make sure that we are helping every single one of our local systems apply for their grants, prepare for the next year, making sure that the grants from last year are still in effect and still being utilized appropriately, that if there needs to be any budget changes or line item changes to their grants, that if, this is a very busy time of our year, it's starting in April actually, where we have we're in the middle of one year, and then the next year applications are due because our statute does require annual grant applications and annual compliance plans to show what local systems are doing. And when we receive these applications from the systems showing, which show us what they need to comply, we go through multi-tiered levels of review, starting with our staff, and then going up through layers of senior staff, then through subcommittees of our commission, and then finally the commission in their public meeting does a full review, and we begin approving compliance plans in the early summertime. So it is a year-long process. And it's not just the approval, the content, not just the approval year long, but also we provide a lot of technical assistance and ways to inform the local systems and our local partners. For example, we have our MIDC grant agreement that is updated and reviewed every year, approved every single year. The grant manual, which is our policy that are updated around every February's meeting, compiles all allowable uses of our grant funds, all policy work, abstracts of what the statute says. We have a grant management system, which is really this one-stop shop where both our local partners and our office are able to access everyone's compliance plan. It's where reporting is done. It's where we can analyze the data that comes through. We provide court watching and site visits continually at least at every location twice out a year. This is, we are in the field. We have greater rubrics so that we make sure that every single place is being assessed at the same level. And of course, financial audits. The team, looking forward, and this is, just a snapshot again of what we do and how we do it. Going forward, we don't have any more additional standards to being implemented, which is a huge news, right? Those 9 standards, this is, right now, this current year, 2 of the final 2 standards are being implemented. So going forward, we don't anticipate needing additional grant funding for this, for the next year. However, operations, as I mentioned, we're a small but mighty team. I'm constantly concerned and want to support my team in terms of our financial and compliance oversight, making sure that we're transparent, because this is state dollars going out and being spent to support local systems. And that we want to make sure that we're always providing as much technical assistance and customer service at the best level, and supporting things like our annual attorney trainings and oversight of attorneys' qualifications. So the request of needs for next year is an additional 4 FTEs that would support those activities. And the impact, right? And so, so that's how we do it. What I'd like to talk about is that since our grants have only been in the field since 2019, so it has taken a little bit of time to see what we're changing, what it looks like. But these are the questions things that we're able to now talk about. For example, I mentioned that we have our local funding units. It's 133 of these local funding units out there, and they each get to decide how they're going to meet our minimum compliance standards. They've created 35 public defender offices. Some are regionalized, and it covers 40 counties. The remainder are things called managed assigned counsel systems. We now know that there's just over 1,700 attorneys accepting public defense cases. It's only 4% of all licensed and active attorneys in the state of Michigan. And we know that of that 4%, they take 85% of the criminal criminal cases that come into to us at the trial level. What have we done? One of our biggest standards, one of the biggest changes that we saw was when we implemented and helped local systems implement what we call counsel at first appearance. There was only one district court that was, before our standards existed, that was doing it continually. Now all of them are. And what we know now is that or just last year, we had over 295,000 people that were provided a public defender at the first appearance during arraignments. Again, this represents about 86% of all arraignments statewide. And we know that there's national data that shows that this can greatly improve a person's life, can greatly improve the reduction of pretrial incarceration, which helps with cost savings, of course, to us in terms of incarceration, but also human costs, so that a person who is awaiting trial can actually go home, can make sure that they can pay their rent or their mortgage, can keep their job. We see that the data nationally shows us that clients who have counsel at first appearance are more than 2 times as likely to be released without bail because of better advocacy and being able to really better advocate for themselves at this point in the court process. We see that clients that if they are not released without bail, that they are given a reduction at the bail sentence, 5 times more likely if an attorney is there with them. And of course, it actually, having your attorney be there with you right in the very beginning, it builds a moment of trust for the judicial system, for the legal system, that, otherwise you are, and we see the data showing that clients who are released are much more significantly likely to come back to court, to show up, that the failure to reappear is reduced by about 2/3. I talk a lot about the culture of public defense changing, because these standards really, they never existed before. These bare minimum types of standards in terms of providing livable wages, ensuring that clients have, attorneys have time to actually focus, to do research on their case, to actually advocate zealously, that attorneys are afforded proper expert and investigation services. We are funding, we've seen a massive increase of expert usage just from last year, 41% of increase from last year. While the number might look small, that is a huge improvement. We are, the grant funding supports non-attorney experts and staff members, things like client advocates, social workers, mitigation specialists, who are able to really just help connect better with the client, but also to help better advocate, to ensure that clients are receiving the sentence that best, if they're receiving a sentence that it best is suited for that person individually, that they are able to be rehabilitated and to come back into the community as productive citizens. We have, and we also support specialty courts, defense attorneys that are part of the specialty court teams, really innovative things that are happening across the state. These types of services, there's national data, again, that shows us that when these non-attorney changes in culture of being a part of the public defense team, there's massive reductions in terms of wrongful capital convictions, so that we're actually making sure that the right person who did commit the crime is being charged, that we're seeing a massive increase in terms of possibility of parole on the other side, of increase about 62%. And we're seeing reduced prison lengths, again, because we're able to reduce disproportionate sentencing and make the outcome more individualized, reducing that by nearly 1/4. We're also, I mentioned our training programs, because it's really pretty amazing what we've been able to accomplish. And just when we have that statutory mandate to encourage innovation and best practices, we took that to heart. We've been able to promote internships for the first time. We've in our PD offices and our managed assigned counsel systems. We partner with all 5 of our law schools to make sure that those graduates stay in the state of Michigan, whereas they used to be leaving our state to go find jobs elsewhere. to work in public defense. We've worked with Wayne State Law. I really love talking about this. It's the first that I know of in the country. We've created a holistic defense fellowship. Wayne State helped us, craft the curriculum, and we now place about 20 students statewide, both law student and social work graduate students, to work for the summers in places that are typically hard to recruit and retain attorneys. We have trial skill simulation programs. These are currently grant funded by the Department of Justice, but we that are training on an average 2,500 to 3,000 attorneys each year. We've been able to then also beef up the partnerships that we have with our training providers that exist independently of our office. We work very closely with the Criminal Defense Attorneys of Michigan Association, with local bar associations, with partners nationally that come in and provide us with training. It's really been an excellent way of being innovative. And of course, when we're talking about not just innovations and changing culture, when we're actually able to appropriately provide efficient and effective counsel, we actually see that trained and qualified public defenders are much more likely to prevent wrongful convictions, that we're able to reduce disproportionate and lengthy sentences, and that equates to dollars and cents, right? I mean, so this is, Michigan-specific data shows us that every time a dollar is spent on hiring a new public defender to ensure that caseloads are being capped and attorneys are not being overworked, that we actually save just over $6 in incarceration costs because, again, of wrongful convictions being reduced and disproportionate sentencing lengths being reduced. All of this, we've come so far in just a handful of years. Before our office was in existence in 2008, we had an independent study that was produced showing us that we were pretty dismal in terms of what we were doing here. It was the state of public defense in our state was at the bottom. We were about $120 million short in that year, so that's been a couple years now in terms of national averaging of spending. But fast forward 15 years, and we are now the national leaders. We have, when I speak to counterparts of mine in other states, they've coined the term the Michigan model. This is, people want to follow what we're doing and maintaining, just the best types of practices and seeing these improvements. And we're not done. And currently, there's an active bill moving fairly quickly through our legislature here that is similar to something that existed in last session that would expand us to our natural next step, including youth defense services. It's a bill being led by Representative Leitner. Again, same type of model, where there's independent studies showing that our youth defense services are bare bones at the very bottom, and that there are recommendations to move us to this Michigan model in terms of representing young people in juvenile court. And just to recap, the investment that is so necessary in public defense, yes, of course, it's a mandated constitutional obligation that our state has, but we're meeting it with gusto. We're doing it the best, as far as I'm concerned, but also that we're supporting our local communities. We're providing real-time technical assistance, customer service, increasing the public safety, reducing incarceration costs, and yes, ensuring that every person is given their due process. Thank you.
I have a few questions before
Please.
we take questions for you. I want to, first of all, realize that we started 2013, is that what I saw, the Public Act?
Yeah, the Public Act was on.
So in 2013, right? And that's basically 11 years from now? I mean, it took probably a year to get everything.
A couple more. Yeah, we didn't start, I count 2019, that's our first time grants were flowing, so we really weren't able to, took quite a bit of time to develop our standards, actually get some staff. And
Perfect. And and since then, we went from 44th out of 50, so it's like our educational level. We're in the 41st, 42nd ranked in the state of Michigan, and we went to number 1 in what? How many years?
If you're counting from 19 to now, that's only a handful of about 6 years. So.
And the best thing about this department is it's new, and you guys have a passion to make it better. I'm not trying to say that the rest of our departments aren't like that, but it seems like you guys came in at the right time to make sure that we are not looking behind and we're like everybody else is trying to catch up to us. It's not the same in some of the other systems in our state. I wanted to ask you about the cost. I had it flagged. My concern is the cost of independence. I realized that we're independent from the judiciary. We're thrown into this department so that there's not. My cost is why, or is there any way that you can regulate the cost you guys are paying to the actual cost of our prosecutor? So the concern is, are the dollars even, right? Like, hey, can we pay 120 to an hour? I'm just using it as an example. When our public defense is basically doing the same thing at $45 an hour, only because I like a fair. It'd be like you playing golf against Bob, my scratch golfer, versus somebody that is not a good golfer, right?
Right.
And I use this analysis because I would like to see if you guys got a cost analysis to base it, and because I mean some areas don't need the same.
Sure.
That was my first question, if I could get that. And the last other question is, I am so impressed that we're the national leader with a team of your size, right? And I realize that looking at your past, every time that we add another set of rules, mandates, right, for you guys to go by, and this happens to all businesses, you're seeing the cost right here. But this has actually happened to our state small businesses, and every time we throw another mandate, we've got to figure out how to pay for this. And at a state level, like you can see it, like bam, bam, bam. And I really appreciate maybe we don't make some more mandates, and you guys use the money to fund. The other thing was your work projects. If I remember right, you only have 4 years to use those, right?
Correct, yes.
So what is the plan to use the 21 work project? And I saw it in here. Do you have plans? Can you show me what the plans is to use that work project so that you don't lose that?
Sure. So I'll start with the first question, if that's okay.
Go ahead.
Threw a couple at me. First, with what I would call parity with prosecutions, our standards are actually. I think it's a little different to just take our budget and compare it directly to the prosecutor's budget. That is, it's funded locally, so prosecutors are funded at the local level, of course. But also, the prosecutor budget is not just their offices. It's if we have investigators, their investigators are the police department. If they have experts, their experts are the forensic center, or there's other types of pots of money that it's not just rolled into this one budget line item that we provide in grants. They also have corrections, and that's related in those costs, or the AG's office, which is also a prosecutorial arm. So if you roll all of those things in and look at it that way, they also have funding that goes through their training arc and PAM and PAC. I have not actually done that math. If you roll in all of the budgets from those departments and then compare it to ours, I don't know. But I can tell you that before our standards existed, we were paying attorneys. If you're just focusing on the pays and the wages, attorneys were being paid at like $20 an hour in some instances. So we were just bringing it back up to where it should have been all along, where that we can actually make sure that we're not pitting people's livelihoods against the clients that they're assigned. And disincentivizing the work. So I don't know the numbers. We can certainly do some number crunching for you. But again, we also very much support prosecutorial funding. They're our partners. We have a seat for them on our commission. It's about making sure that the entire ecosystem of the criminal legal system is being well supported and resourced. I don't know in terms of what we could regulate in that aspect of things, but I do think that our minimum standards of pay rates have, they include COLAs, just like, every other type of civil service scenario because of state dollars. Our standard for pay also is, the guideline is to pay on the same line as the attorney generals, assistant attorney generals. So whatever their what their civil service ranking is, sort of like a 13 or a 9, that's, if you're a salaried employee locally at a public defender office, it should match that type of standard. So that is pretty much already built in. It's because this is being paid for by state dollars, not local dollars, right? And the The going rate that we have, the minimum pay rate, is still incredibly significantly less than the going rate for retained counsel, which I think I just saw the other day. The state bar does like an annual, or every couple of years, an average pay rate. If you're a retained criminal defense attorney, it wages somewhere between $300 to $500 an hour. Our minimum rates are going rates of around 120 for misdemeanor cases, if not a little higher. And so, again, it's really not pitting prosecutor. We're about making sure that simply because you're poor doesn't mean that you're going to get less than you could if you can pay for an attorney. And so it's about making sure that it's equal playing field for everybody. I hope that answered part of the first question.
Yes.
Second question, in terms of no more mandates, you're right. We don't have any more standards that are pending. So I hope to see this static number going forward. However, I did mention the expansion of youth offense. Now, there's been, so I do expect more work to be done, and I think we shouldn't stop, right? We're still new. I think we still have a long way to go in a lot of instances. But for the next couple of years, I don't see a need for a big jump in grant dollars for that pocket of our budget, especially if we are focusing on youth defense. It'll take a couple of years to actually create new standards, to get things going, to work with the local systems. I mean, we'd be starting from scratch in that instance. So hopefully that actually levels out. And in terms of work project, let's go back to that slide.
Yeah, I got it.
Sure.
39.
Yeah, gotcha. So we've,
I'm just.
so look, a lot of this, like I mentioned, comes from unexpended balances locally. This is from, in year 22, 23, those were years that we implemented really big changes locally, and a lot of our systems had to make educated guesses about what the costs were going to look like. And we did our best to work with it. We do so much partnership in this. But in a lot of instances, there was overestimations, or it takes a lot of time to actually hire people. Hiring is a huge, right, because the grants fund 90% of people. If there's a hiring shortage, if you lose people, if you can't retain folks, then you're going to have a big gap in your budget of leftover funds that are unexpended. And so that's a big part of this. Also, all of the startup time that is needed to actually create a brand new local county office. So a lot of this, and of course, those years we're still dealing with leftover COVID case log cases. So we really, getting our first grant year, and then the next year was COVID years. So it really, a lot of this funding is left from those case backlogs, and we wanted to make sure that it existed there. I know that, for example, the city of Detroit is still way backlogged. I know it's been a couple years since there's been closures, but it's still there. So we have this money set aside. Of course, I also can't predict any type of mid-year Supreme Court case law changes. That has been a big pot of money that we've needed to set aside. Each one of these, it's now estimated around 200 individuals will be retried or resentenced at the local level. Each one of those cases, we estimate about $40,000 in addition for expert and investigative funds. If you take 200 times 40,000, it's a fairly large number. It doesn't cover all of this money that's set aside here. And I do realize that it's not going to happen. All of those cases won't be retried on one day. But it's important for us to make sure that we're not underfunded and we have the money and resources there for our local systems.
Oh, just the last question.
Yes.
And then I'll have questions for you folks. What happens if they're not a U.S. citizen? This is, I mean, it's our money, right? We all pay these taxes in Michigan. So what happens if it's not a U.S. citizen? I get that we have to take the overlap because that's just like anybody else coming in our county for hunting or fishing or whatever from the U.S. But do we use this money to fund those? Because I mean, I'm sure they don't have anything if they're here. So how does that work in our system here?
Sure. So the U.S. Supreme Court, under the most recent cases under U.S. v. Padilla, explicitly states that the Sixth Amendment, effective rights to counsel and due process is afforded to anyone hauled into court. So regardless of immigration or citizen status. So that's
okay. Thank you.
Yep.
No. One question from Rep. Steele.
Thank you, and thanks for doing the Zoom call the other day. You
Absolutely.
put a lot of this in perspective, but I just have to go back to Chair's question about the pay parity and why we're not allowing the free market to dictate what the attorneys get paid. I mean, so you're saying that the state pays it and you can't really make a decision on what the counties or the townships pay their attorneys, but it's like, I just look at the victims of the crimes that are committed and the prosecutors that are there to convict the criminals to be able to make sure the victims are taken care of as well too. And if they're getting paid less, you're going to have more people be defendants versus prosecutors. And so why is it the commission's duty to dictate what the rates are versus what the free market is? Sure. And you say that they're funded by the local level. However, you're also funded by the local level, but it's not, the fees aren't being collected appropriately to be able to offset some of the costs, and where the fees are completely paid for by the prosecutors, and therefore it makes it an unfair advantage. So it's not a free market. So I guess I say all that to say is, are we able to do a dollar per attorney, like per hour? What's the prosecutors get per hour versus what your attorneys get, or these defendant attorneys get per hour? And you said $40,000 per case. What's the cases for the prosecutors? Are they getting $40,000 per case?
Sure. And just to clarify, that $40,000 number is solely for retrials of resentencing from the juvenile life without parole cases that came very specifically from Michigan Supreme Court. So I wouldn't use that number. And that $40,000 is an estimate per case for expert and investigative use. So it's really for those individual types of cases. So that's not a number we use per case out in the field at the trial level on a normal basis. So I wouldn't use that number for this instance. Sure, a couple of things. First off, our statutory mandate was to create a standard that regulates attorney pay, that ensures that there's not that regulates attorney pay for defense services. So we have a statutory mandate where we had to create the standard. The attorney compensation standard, again, it ensures that there's not a disincentive to do the work. This work that is constitutionally mandated, that it protects from government overreach, from abuse of power, from disproportionate sentencing. These are wages that were never in parity ever with the defense bar, with the prosecution until we existed. Again, we knew that attorneys, from a very basic overview, we knew attorneys, I mentioned $20 an hour, sometimes even lower, because many places where they would pay solely based on a fee for service or a contract, there was no incentive if you would get paid $700 for a trial in some cases. It didn't matter how many hours you put into it. You would be paid on flat fee contracts, maybe $10,000 a year, no matter how many cases you had to receive or how much work had to get done. And again, this is state money. I actually think that in some instances there's a lot of local systems where the prosecutors and defense attorney are on parity. I think that's actually pretty clear. And again, because it is state dollars, we actually use the state, also the state prosecutors' rates, to use them as a guideline of pay parity. So we are doing apples to apples in that instance.
But not apples to prosecutors.
The AGs are prosecutors.
In the local court system?
No, but they are the state-funded prosecutors, and these are state-funded defense attorneys. And so that's...
We just have a hard time filling the prosecutors' positions in the local court system.
I know. And we do too in terms of defense counsel, and it's a real problem in terms of retention and recruitment. That's why we're trying to help bring people, any attorney that wants to do or any type of public service work, including civil work. A lot of our friends in legal aid services are having very similar problems as well.
And then just the parity between counties, are we keeping track of that too? Is Kent County getting the same as like Wayne County?
Yep, so these are all minimum standards. So each county comes to us telling us how they're going to comply. So they have to meet a very these are the basics, right? They can, and our commission has approved over and above funding, if but within reason. We have a statutory mandate to only fund those fund costs that are reasonably and directly related to public defense, and so we're not going to be, to quote a past commissioner, we're not going to be funding gold toilets, if you will, but we will be funding things that are very closely connected, and if they're to use the free market term, we know that a lot of our offices compete with federal defender rates, and so within the Oakland, Wayne, and Macomb areas, as well as in Kent County, because that's where our federal defender offices are located, so that they can go above our bare minimum of pay, so that they can make sure that we're actually able to keep the attorneys on the rosters in those areas as well. So. Not every place pays exactly the same, because not every county is exactly the same. That's never gonna work, but we will make sure that they are always paying at least the minimum of what we require.
All right. Thank you, Director. I appreciate your presentation, and I'll be looking forward. I have some other questions, but we'll meet up afterwards. So
Sounds good, thank you all.
thank you. Next up, we have the Michigan Public Service Commission. Chair Dan Scripps, can you give us your presentation, please?
Mr. Chairman, members of the committee, thanks for the opportunity to be with you this morning. I am happy to talk about the commission and what we do on behalf of the folks of Michigan. I wanted to first introduce Rika Holly-Velker, who I think a number of you already know. She's our legislative liaison. Great point of contact, both for any policy or budget-related issues, but also if you're getting constituent inquiries on literally anything that's energy or telecommunications related. She's great at working through those, former legislative staffer herself, and great point of contact. And Representative Van Workum, apologies for wearing the Alma College tie this morning. I hope it doesn't spark any MIAA feuds as we kick things off. Just a few words about who we are as the commission. The commission's roots actually go back to 1873 and the Michigan Railroad Commission, but rest assured, Mr. Chairman, we still have a passion to make it better, even if we're 152 years old. Today, we are the regulator of Michigan's electric and natural gas utilities. We also have some oversight of telecommunications, including landlines. Telecommunications work also involves efforts around access to 211 and the emergency 911 upgrade reimbursements, and we have a role in advising the governor with respect to energy emergencies, including concerns around propane supply, delivery capacity, as well as other energy emergencies that might arise. There are 3 members of the commission. Each of us are appointed to 6-year terms by the governor with the advice and consent of the state senate. We serve staggered terms, so there's not the sort of turnover that you might see if everybody left at one time. Have some protections in statute, can be removed for misfeasance, malfeasance, and nonfeasance, but in an effort to preserve some level of independence in evaluating long-term infrastructure investments and service quality. The commission is a creature of statute. We carry out our statutory authority through the orders issued in our cases, and we take that role of being a creature of statute very, very seriously. I just want to talk briefly around the commission's contested case process, because while we use a range of comment dockets, work groups, technical conferences, and the like to allow for collaborative development of solutions, most of our decisions are required to go through a contested case process. These include things like rate cases, long-term planning cases, siting cases, cases regarding violations of important safety standards, cost recovery cases, and the like. And these cases are overseen by an administrative law judge and have many features reminiscent of a courtroom: testimony, exhibits, cross-examination, motions, briefing, and are conducted pursuant to the Administrative Procedures Act, as well as Michigan court rules, procedural rules, and rules of evidence. And so it really is that quasi-judicial function in evaluating the merits of the arguments that are put forth on the record. And in evaluating those arguments, the Commission is ultimately assisted by staff attorneys and advisors as we prepare our orders. At all points, the Commission's orders must be consistent with the evidence submitted in the case and the statute governing the issue. Our orders ultimately can be appealed to the courts, and those courts have provided valuable guidance and guardrails, including a fairly famous, at least in the utility space, Michigan Supreme Court decision in Union Carbide Corporation versus the Public Service Commission, which we affectionately refer to as Union Carbide, that ultimately found that we can't make management decisions on behalf of the utilities, that we oversee them and we regulate them, but the management of those is left to the companies themselves. So again, we routinely say that we're a creature of statute. We take that role very seriously. And then finally, before leaving this slide, just wanted to highlight that picture in the lower left. That came from the Palisades nuclear plant. It's actually the training control room, but it's identical in all respects to the actual control room. We've been encouraged to see progress in bringing Palisades back online. It will be the first ever retired reactor brought back online in the United States. And we're particularly heartened that progress continues, including the announcement earlier this week from U.S. Energy Secretary Chris Wright regarding the latest federal funding disbursement. So we're fingers crossed, but things are moving in the right direction. The Commission is staffed by approximately 220 professionals, and they have a broad range of expertise running from engineering, economics, accounting, auditing, customer service, law, and a number of other fields. What's important, and I think often under-recognized, is that our staff, particularly the engineering and accounting and professional staff that reports ultimately to our Chief Operating Officer, they actually serve as independent experts in our cases. They are literally in every single proceeding that the Commission opens. So you'll have an applicant, a utility or telecommunications provider, and our staff are in every single one of those, providing their independent judgment, evidence on the record that we can then take into account in making our decisions. And so that's an important piece to make sure that we have, in addition to the applicant, the company that's seeking a rate case or a approval of a long-term energy plan, that we also have, at least in our staff, one other party providing independent expertise that we can then use as the basis as we issue decisions. Turning to our mission, I love our mission. I'll just say that. It's a weird thing to love, but I think it really captures what we do. So to serve the public by ensuring safe, reliable, and accessible energy and telecommunication services at reasonable rates. And I think every word is important, including that we start by saying that our primary role is to serve the public. You could put a period at the end of that and capture most of what we do. But we then unpack it a little bit. We're looking at safety, reliability, and accessibility in the two industries that we oversee, energy and telecommunications, and we always have to keep in mind that affordability piece, that those services need to be provided at reasonable rates. So that really is a lodestar in addition to our commitment to being creatures of statute as we conduct our work. Turning to our funding, and this is this year's funding. I'm not going to talk about next year's, but I'm happy to answer questions if you have them. Our operational costs are covered by two revenue streams. The first is the Public Utilities Assessment, or PUA. It's a restricted fund that was established under Public Act 299 of 1972, and it's made against regulated utilities, so investor-owned utilities, cooperative utilities, telecommunication companies, and it's designed to cover the costs to regulate them. So the idea here is that regulated entities should pay the cost of their regulation. And that accounts for the majority of our budget. So it's about 83% of current year budget. Of that, about $1.25 million was approved to conduct one-time studies connected to the implementation of the 2023 energy laws, but the remainder of the PUA allocation is for operations, and that's consistent year to year. The other major bucket of funding is federal gas safety grants. So the Commission conducts pipeline safety inspection and carries out enforcement actions against pipeline operators under an agreement that involves delegated authority from the Federal Pipeline and Hazardous Materials Safety Administration, or PHMSA. And as part of our agreement with PHMSA, the Commission is eligible to receive up to 80% of our costs for the program from the federal government. So we have delegated authority, they provide the cost to cover that. Unfortunately, the federal government over the last number of years has set reimbursement rates lower than the 80%. So authorized is 80%, appropriated is less than that. So that creates a bit of a hole in our operating budget, which typically is around $350,000. It's an issue across the country, and along with a number of other state utility commissions from all of the other 49 states, we're continuing to work with our national association for those reimbursements to be increased to the approved levels. And then finally, in the current year's budget, you see some general fund dollars. The only time that we get general fund historically has been to support grant making. So whether that's Michigan Saves, the low carbon energy infrastructure enhancement and development grants, or the more recent renewable energy and electrification enhancement and development grants, both of which we refer to as EIED, because we love acronyms. But that really is the only place where we get general fund dollars, and those dollars are not being sought at this point for next year's budget. Looking at our major functions, I'll walk through these fairly quickly, and then excited to get to some of our more recent activities and goals for the year ahead, and then to answer your questions. But ensuring system reliability, including developing and enforcing rules around reliability, tracking outage information, and then a whole suite of approaches to improve reliability, including investments that are proposed in utility rate cases, utility distribution plans, the first of its kind independent audit into the utility distribution systems, some performance-based regulatory approaches to better tie utility performance to how they earn money, including both upsides and downsides for the utilities. So a broad approach to system reliability. We're also focused on setting just and reasonable rates again. That largely takes place in the rate case reviews and rate setting, but also in advocacy at the federal government and with the regional transmission organizations around the rates set by federally regulated entities, pipeline operators, transmission companies, so that the costs ultimately borne by Michigan customers are fair and reflect cost of service. Under energy assurance and planning, we review utility long-term integrated resource plans and the capacity demonstrations that are submitted by all electricity providers. There's also a fair amount of work at the regional transmission organizations on a range of issues, including price signals for needed capacity and other resource adequacy initiatives, reforms to the interconnection queue process, long-term transmission planning, and the like. In addition, we also, as I mentioned earlier, advise the governor on energy emergencies, represent or have a seat at the State Emergency Operations Center, monitor energy supply, and conduct and issue biannual energy appraisals. One, as we get into the summer season, looking at the price of gasoline as well as electricity availability as we get into some of the peak months, and then going into winter, looking at the availability and price for propane and other heating fuels. We also license and foster competitive markets, both in telecommunications licensing and the licensing of alternative electric and gas suppliers, as well as addressing fraudulent or otherwise problematic marketing practices that come up from time to time, and I'm sure you hear about from your constituents as well. Facility siting and need determination. On the siting side, we have siting authority over some of the pipelines, both on the natural gas and petroleum and hazardous materials side, as well as siting authority for electric transmission lines of certain lengths and voltages, and more recently some renewable energy resources as well. We also play a role in need determinations for electric generation, transmission facilities, and pipelines as well. On public safety and oversight, again, pipeline inspections, incident investigations, the enforcement of the MISDIG Act, and approval of the emergency 911 cost reimbursements. And then finally, on customer assistance and protections, issuing telecommunications orders, conducting regulatory reviews needed to enable access to 211. We manage the Michigan Energy Assistance Program, or MEAP, which provides assistance to, this year, more than 50,000 households annually in each of Michigan's 83 counties, and also address utility customer questions and complaints, providing assistance regarding telecommunication customer concerns, including phone and cable. We don't have authority over the internet, but our team does have, as you would expect, relationships with the providers, and we work to facilitate resolutions and answer customer questions when we're able to, even in the absence of specific authority. Last year, our energy and telecommunications staff responded to more than 11,000 customer inquiries, Our on-hold time, we take some degree of pride in this, is 15 seconds before you're getting a live person in our energy call center. And when we look at the time to close a customer inquiry or complaint, it averaged 10.3 days for business complaints or for residential complaints, and 11.8 days for business complaints on the energy side, and 11.4 days on the telecommunications side for residential complaints, and 15 days. And that often involves significant back and forth between our staff and the company. And the reason that it's a little longer on the telecommunications side is we have less enforcement authority, and so sometimes it just takes a little bit longer to get those calls returned. Moving into our priorities from 2024, I'll go fairly quickly. I want to get to your questions, but we took several steps last year aimed at improving reliability of the distribution system. A few of those I've already talked about and are highlighted here. I want to be really clear. We're still not where we want to be or need to be in terms of reliability. But we are making progress. So Consumers Energy, for example, announced that in 2024, the average customer experienced 21 fewer power outage minutes compared to 2023. That's the best improvement in a decade. It sounds relatively small, but 21 minutes is a significant step forward and the best improvement we've seen in a decade. They also were able to restore power to 93% of their customers within 24 hours, and that's up from 87% the year before. For DTE, they announced a 70% improvement in time spent without power in 2024 over the year before, due in part to grid improvements and part in the better weather that we had in 2024 over 2023 obviously played a role as well. I've talked about our work in ensuring resource adequacy through long-term utility plans, as well as our work at the RTOs. Significant ongoing casework. So last year we issued 389 orders. There are literally thousands of pages of testimony connected to some of those, but we're issuing more than one order a day on average, and I just want to note that we hit 100% of our case-related statutory deadlines. It's something that we take very seriously. In terms of the federal funding that was available, we actually got more federal funding into Michigan for energy-related projects than any other state in the country. And then more recently, the U.S. Department of Energy announced more than $14 billion in federal loans. I'd note those commitments haven't been finalized. We're paying close attention to those. But it's for both gas and electric improvements that would offset the work that's already being planned and undertaken related to gas safety and main replacement, as well as deferring or offsetting some of the costs for electricity projects, including renewable siting projects. I'd also note on the EIED grants that we can, that this is something that we issued $20.8 million to 19 grantees under the Renewable Energy and Electrification Grant Program, and continue to monitor the $50 million that was provided under the Low Carbon Grant Program in fiscal year 22 and 23. And just to highlight some of those, they included a planning grant to Midland Cogeneration Venture for a carbon capture and sequestration feasibility feed study, a grant to Pioneer Services in Muskegon for a solar array that will save that nonprofit organization $40,000 a year that they can put back into their other activities. The Capuchin Soup Kitchens in the city of Detroit partnered with an organization called EcoWorks around 4 solar and storage projects, and then grants to Consumers Energy for renewable natural gas projects and planning for networked geothermal systems. So a range of things that we think are showing up and making a difference in communities across the state. And then I will touch on the other two in these slides. So at the end of 2023, as all of you know, the legislature enacted a series of energy reforms. We've been hard at work implementing those, including drafting filing requirements around the updated integrated resource plans and initiating the required studies. For renewable energy plans, all of the renewable energy plans, except for one co-op and 2 alternative electric suppliers, have been filed with the commission. We're working through those. Those have 300-day statutory timelines. We've also reviewed and updated interconnection procedures for all investor-owned utilities, working on updates to the energy waste reduction framework, including contested case proceeding to finalize and adopt the final framework for those programs. Just on that, I would note that earlier this week, the American Council for an Energy Efficient Economy ranked Michigan actually #1 in the country, or tied for #1 in terms of our utility and public benefits energy efficiency programs. That's up from number 3 last year. We were actually number 1 in terms of the gas saved as a percentage of retail sales, and number 2 in terms of the electricity saved as a percentage of retail sales. And I just note that we do it much more efficiently than other states. So we're number 2 in electricity savings, but we're not even in the top 10 in terms of the dollars that we ultimately spend on that. So seeing real best-in-class results for Michigan utility customers. And then on siting, which I would expect I'll get some questions on because I usually do, we have adopted an order finalizing the application process and are working forward to carry out the changes that were included in statute. We had a number of one-time projects as well. The UP Energy study was submitted to the docket on time and delivered to the legislature on December 2nd, 2024. We also had a study on storage opportunities that we partnered with some national labs and others on. That was delivered to the legislature at the end of last month. We were directed to initiate a proceeding to explore opportunities to improve the rate case process. We did that at the end of May and have received a number of comments from individuals to improve those processes, and then also to initiate a proceeding to explore opportunities to expand opportunities for engagement in our decision-making process. We initiated that proceeding in May as well, and then held a public hearing in Flint in August to receive public comment as well as the comments that have been submitted in the docket. Under boilerplate, we're required to hold 4 public hearings each year. We held 7 this past year, and so it's something where we continue to over-deliver on the requirements that are expected of us. And that's in addition to the 17 regular commission meetings that we held over the course of the year. It is included in the 66 public meetings that we held. That includes work groups, technical conferences, and these public hearings as well. So continue to get out and expand our opportunities to reach the people of Michigan and make sure that their voices are heard in our processes. Looking at our 2025 priorities, again, the obsessive focus on improving reliability. Earlier this month, issued our final order in adopting financial incentives and disincentives. This is really focused on the core pain points of customers, including the duration of outages in both storm and non-storm events, restoration timelines, the number of customers experiencing multiple outages outside of our service quality rules, and an examination of the worst performing circuit. So it's not the same customers getting the worst service year in and year out. We also have been given $4.9 million for EIED grants in this fiscal year, and working to implement the MEP updates that were enacted at the end of last year to expand program eligibility and funding, and that's done in partnership with DHHS and, again, our network of grantees around the state. We also, by the way, launched a podcast, which is called Behind the Meter, and so as you're traveling back to your districts, I encourage you to check out the first 2 episodes that were recently published. So that's where I'll leave it. I'm happy to answer any questions about any of our activities, our budget either this year or looking forward, and look forward to your feedback.
Thank you, Chair. I'm going to go back to your first page, who we are. So you said that can you tell me when Catherine, yourself, and Alessandra can you give me the year that they got?
Sure.
Yeah.
So I was appointed initially in February of 2019 to fill out the remainder of the term of State Treasurer Rachel Eubanks. That went through 2023, and then I was reappointed at that time for a full 6-year term that expires in 2029. Catherine Paratek was appointed in January of 2021 to fill out the last 6 months of former Chair Sally Talberg's term, and then in the summer of 2021 she was reappointed for a full 6-year term that expires in July 2027. And Alessandra Carrion was appointed 2 years ago to fill out the final 2 years of former Commissioner Tremaine Phillips, so her appointment is up this summer in July.
Because something you said there that you go through the Senate, correct? Yeah.
Correct.
But not when the governor owns the House, the Senate, and there's no Senate hearing then. It is just approved through without. That's my concern without having a senator that might be a Republican on the thing. You guys are just pushed through and not going through the legal remorse of, hey, we want to know about you, and it's just another appointment by the governor without proper venting. So that's my concern when everybody's coming up, because I don't have a senator anymore in my area, and you're very aware of that. And this is concerning to me that we are going to push through people without proper representation from our area. So, and then everything else is, I really do appreciate your presentation and learning all about you. I'll kind of meet with you off. I would like to go to some of these spots. I'm happy to meet my smile with the nuclear power, because I have actually owned a business that paid over $1.2 million in 20 years to Consumer Power, and I wasn't very happy with that because my margins were so close on retail that it could have been a lot beneficial if we would have helped the small businesses out earlier than what you guys are doing now. I appreciate what we've done now, but we've lost a lot in the. So go ahead. I have Rep. Steele with a question.
Just a real quick, in comparison to other states, where do our energy rates align? Like, are we, I know in schools we're like 47th from the bottom. And so apparently, but MIDC, we're number one. So where are we with energy costs?
Yeah, so we're, our energy rates, and they're different between commercial, industrial, and residential customers. So I'll cover those specifically. So for for residential customer rates, we are higher than average. When you look at customer bills, the actual amount paid, we are about average. And those are often, that's the trend that you often see, in part because when you look at rates, they are designed to recover on a per kilowatt basis or per therm on the gas side, both the fixed and variable costs of the system. And so if you end up using more of that product of electricity, the rates can be lower in order to get the same revenue requirement. And so our rates are higher, but for a number of reasons, including the fact that that we really don't have much electrified heating in Michigan like they do in the South, and that we don't have the same summer peaks in Michigan for air conditioning load like they do in the South. We end up using, and our best-in-class energy waste reduction programs, don't want to leave that out. We end up using fewer units of electricity, and so you pay more for each unit, but when you look at the overall bill that the customer pays, it's basically middle of the pack. For industrial customers in particular that are more rate exposed, our rates have traditionally been fairly competitive, and so they're lower because of the way that the industrial customers use electricity. They have a lower cost to serve, and ultimately the rates reflect that as well.
Do you have a chart that says all that?
Yeah, I can follow up with you.
Rep. Van Workum.
Thank you, Mr. Chair. And since you didn't wear a hope tie, I'll try and make this more about appropriations.
My dad's a Calvin grad, just to be clear about that on the record. So I don't know how I went wrong.
Hey. So I was looking through the House Fiscal Analysis. You have 223 FTEs. You're kind of all rolled up into one line item here. So it's kind of difficult to assess where those, how that's proportioned. So my question is about the siting. How many people are within that siting category that when a local ordinance isn't there, then they can approach you guys of doing the siting? And then how many of those cases have you taken?
Yep. So we created a new renewable energy siting section following the enactment of that law. We've hired a section manager, Sarah Molkoff, and we have 4 additional individuals who work in that section. We have not had any cases filed with us at this point. I'm not all that surprised by that, in part because that piece of the legislation didn't take effect until November. And then there's essentially a process where you need to start at the local level still, with certain exceptions, where those exceptions are where the local government asks that the case ultimately go to the commission instead of being evaluated locally, or where there's a moratorium in place, and so there's sort of the impossibility of having a compatible renewable energy ordinance under the statute. But in other cases, you have to start at the local level, and that process has some initial work that needs to be done with the township supervisor or other chief elected official of the local government, and then a process where it takes at least 4 months, and you have to do that before you can approach the commission. So we're still trying to evaluate how many cases that we'll get. We've spoken to the utilities and some of the developers around where they are in the process and their expectations, and that's how we tried to right-size this. We have not hired all of the employees connected with the appropriation or the increase in our FTEs, and that has been in some parts intentional, because we don't know exactly how many cases we'll get. Is one section going to be enough? Do we need more than that? And I think we'll know more over the course of the next year as we start seeing some of those cases. I've said from the beginning, I'd love that we never get a case, that these things continue to get worked out at the local level, and this provides some encouragement to try and find a way to yes that works both for the project but also for that local community. I'm not naive enough to believe that we'll ultimately see no projects, but I really don't have a sense of exactly how many we'll get.
Thank you. And I have one last question. Why is it that we have trained residential not to use power a certain time of a day? And that's great, except for with some different workloads, that's not very beneficial. And I know that you guys regulate this or have tried to, but sometimes my family doesn't do laundry from a certain time to a time, and I'm only home for 4 hours, and it's kind of irritating. And they're like, "Oh, we can't do it." And I think to myself, that's funny, because in any other private entity, you would want to make sure that you offer power the same across the board, because that's the idea, that you're supposed to make it, instead of we're making this efficiency time so that we have to use less power when we at our peak. And I think to myself, well, damn, maybe we should have more peak power than we should worry about changing the rate of way somebody's coming home from work and not using power. And what's your take on that?
Yeah, so I'll totally own this. We've approved those changes, and it's designed to actually reflect the costs. So the way that energy gets dispatched into the market is that you take the resources that are sort of must-run resources. Think about a nuclear plant. You can't cycle that up and down. And then those that can bid in at a lower cost. And then as you get towards the peaks, you continue to add sort of increasingly more expensive generation pieces. And so then you get to those sort of end of the stack peaker plants that are more expensive to run, and so if we can reduce the peaks as a result of that, reduce the need to dispatch that next most expensive, that results in a cost savings for all customers. And so it's similar to like Uber surge pricing or the like. It's not as sort of specific as that at this point, in part because customers aren't reading sort of the locational marginal pricing that's sent by the grid operators, but it's designed to better reflect the actual cost of the electricity that's being consumed. And I'd note that we have actually gone back and looked at the data from some of the early years of this. Consumers rolled out their program in specific communities as a pilot program, and we've found cost savings for all customer classes, including for low-income customer classes that often are the least able to sort of adjust because they're working third shift or that sort of thing. We've actually seen a reduction in the overall cost because people have shifted their usage to better match the market prices that show up in our energy markets.
And you don't do that only for residential, not for commercial.
Oh, so for the industrial users that are more price sensitive, typically, if you go visit Hemlock Semiconductor, I'm blown away every time I do, because they're so sophisticated in how they match their production to the energy prices, because electricity is such a significant amount of their cost outlays. And so they've gotten very, very sophisticated at exactly when they run their processes and how to match that to when electricity is cheaper as opposed to when it's more expensive.
And as you sit there, I tell you that the small independent gas station, meat shop that doesn't have those same luxuries. No ifs and buts about it. They're open 24/7, so you can get what you need. Are paying the end price, and that's my major concern. Is you can help, but you actually hurt the small independent business when we do things like this.
We've actually seen the reverse. So I'm happy to, when we follow up, get into some of the data. But because, so it is more expensive on peak, but the offset of that is that it's significantly less expensive off peak. And so even for the folks who really don't have the ability, your old meat market, for example, to shift costs, we're seeing, because they're both paying more when it's on peak, but less when it's off, that there have been savings. So
as a business owner, I just need to be shut down during peak for 2 hours, and then you don't get what you want, and then open up after and get a better savings. I like it.
Thank you, Chair. Thank you so much for your presentation. My allergies are kicking my butt, so forgive my
that
voice.
Time of year.
Yeah, it's that time of the year. I got a lot of questions for you, but I narrowed it down to like 3 areas. So, last year you highlighted in your presentation, the last 2 budget cycles, we put some boilerplate language for MPSC, requiring you guys to meet 4 times a year, throughout different parts of the state. And I saw you highlight in your presentation, are you willing and committed to continuing those meetings?
So,
yeah.
Yes. So first of all, we're a creature of statute. We'll do whatever you tell us to do.
Yeah.
But we will continue to hold public hearings, whether it's in boilerplate or not. I will tell you that. The one downside of having the specifics within it around how many and when we do them or where we do them is, and I'll give you an example. Last year, during the worst of the ice storms, and it's still triggering to talk about, but we wanted to get into the communities that were hardest hit. And so we held one of those public hearings in Jackson and another in Western Wayne County, because the Western Wayne was actually hit harder than the city. But because they're in the same proximity and the requirement is that we have to be in Grand Rapids and we have to be in Detroit, the next time, we have consistently been above the requirements that are included in statute and boilerplate. But when you add the locational pieces to it, it may shift where we are from the place that might have the most intense focus to, gosh, if we do that, we're going to still have to do another one over here. So we'll work through it. We have worked through it, but more flexibility is a good thing, just to make sure that we're going to the places where we think sort of need to have their voices heard the most.
Thank you for that. And then you brought up, weather emergencies and natural disasters are becoming more common statewide and across the country. How prepared is Michigan's power grid to withstand a significant emergency or outage? And how does MPSC and other state agencies plan for a response to such emergency? I remember 2 years ago, we had the late February ice storms. And in my district alone, there wasn't any part of my district that was out consecutively for 45 days. 45 days, my district went through this in the middle of an ice storm. Can you touch on, what you guys are doing and what can we do to strengthen this grid?
Yeah. So there's been a lot of focus on this over the last several years. I remember the first rate case that came up when I was on the commission was issued May 2019, and understanding that tree trimming or trees are still the major contributor to outages. I remember my former colleague Norm Sari saying it's time to trim the damn trees. And so we've been really focused on that, including sort of ring fencing those dollars to make sure that they're only spent on tree trimming and that they're paid for in a way that's more cost effective for customers. But since then, there's been focus on distribution plans and what is the strategy that's driving this. We, out of frustration, significant frustration, ordered a couple of years ago a first of its kind independent third-party audit into the distribution systems of consumers in DTE. What are they doing right? Where are there opportunities for improvement? Looking both at the physical infrastructure as well as their processes. We got that back at the end of last September. We've since then gotten the utility responses to that, as well as public comments, and we'll have additional guidance, but essentially we're dividing responses into 3 buckets. What can we just do now that we don't need to wait, like this is clear and let's just do it? The second bucket is those expenses that are going to be sought for recovery in rate cases, and how do we use the audit results to improve the strategy to get better, faster results on reliability at a more cost-effective price for the customers who are paying them. And the third, in terms of the long-term strategy that the utilities are pursuing, how do we make sure that the audit results and findings are reflected in their longer-term distribution plans, so that we're not just sort of looking at this year, in individual year rate cases, but have some broader, longer-term context. And so I think that's the framework. But we're starting to see improvements because of the tree trimming, because of some other things. Obviously, 24, we didn't have the weather that we did in 23, which is a good thing, but we can't count on it, to your point. And so we need to make sure that we continue to keep our focus on this piece. And I will tell you, it has been an obsessive focus for me and for the commission over the last couple of years, and I don't see that changing.
Thank you. I have one more quick question from Van Workum, and then we have to finish up here.
Thank you, Mr. Chair. Just going back to your mission, to serve the public by ensuring safe, reliable, and accessible energy and telecommunication service at a reasonable price. Trying to understand, you guys are a regulator, and what is that balance between a regulator and an advocate, or an advocate for a certain type of energy, or is there a prohibition as the Public Service Commission? Is there some kind of guiding rule of where that ends, where that begins, or should there not be a pretty stark line between a regulator and an advocate?
Yeah. I think that we're regulators. And so when, for example, looking at an integrated resource plan, the statutory standard that was contained in statute back in 2016 was that a utility's long-term plan needs to be not just reasonable and prudent, but the most reasonable and prudent way of achieving their energy, or meeting their energy and capacity needs over the short, medium, and long term. And so that requires a look at what are the trade-offs between resources, between something that's base load versus something that's dispatchable versus something that's variable but also doesn't have any fuel costs. And how do you get the right mix of those between supply-side resources like generation and demand-side resources like flexibility and energy waste reduction? What is the role of storage or other things? And then how does the transmission system play into that? And so it's really looking at the evidence that's then put forth by the parties on the record around what is the right mix. I will say that most of our integrated resource plan cases have settled, not all of them, and ultimately the process that's outlined in statute has driven parties to figure out what is the right strategy. Some of those are contested settlements, but it's how we've tried to figure out, like, as we have a number of resources that are getting to their retirement dates, how do we maintain resource adequacy at a reasonable price for Michigan customers through this energy transition? But it's very much driven by statute. And when I'm looking at what we have in front of us, it's not what does Dan Scripps think is the right energy mix. It's how do the different resources, both demand side and supply side, fit together to get to that most reasonable and prudent under the statute that's in front of us and based on the evidence in a particular case.
Thank you, Chair Script. I actually appreciate your testimony today, and thank you for answering all the questions. I know that we have one left, but I have a time frame, so thank you.
Absolutely.
And next, I need have a motion for Rep. Van Workum to move to excuse absent members. There being no objection. Okay, so I'll move then to McKinney to approve to move absent members.
I approve.
Okay, with no further being business, this is adjourned.